Hello everyone. The Kenyan democracy is growing and taking a new shape, with a fresh twist coming up from the judiciary on a landmark ruling delivered by the Court of Appeal last week whereby it is no longer a criminal offence in Kenya to publish an allegation or even false information on social media. According to a declaration made by the Court of Appeal, the judges undertook to consider a section of two provisions of the Computer Misuse and Cybercrimes Act, ruling them to be unconstitutional, null and void. In a landmark ruling to regulate the online conduct in Kenya, a three-judge bench, comprising of Justices P.O. Kiagi, Justice Muchelula and their counterpart Justice Korir, actually made a ruling scrapping off sections 22 and 23 of the Act, which were all declared unconstitutional for them being overly broad, and likely to capture or either punish innocent persons. According to sections 22 and 23 of the Act criminalizes the intentional publication of false or any misleading information to social media, or any other public space. According to their explanation, this court decision arose from an appeal filed by the Bloggers Association of Kenya, challenging a 2020 High Court ruling by Justice James Makau, which had upheld the constitutionality of the Act. According to an earlier petition filed by the Bloggers Association of Kenya, they were seeking to have multiple sections of the Computer Misuse and Cybercrimes Act of 2018 to be declared unconstitutional up to the latter. In their argument, the Act was found to be infringing on the basic rights about freedom of expression, privacy and the freedom of fair trial whereby the appellate court found most provisions of the law to be constitutional and justified under Article 24 of the Constitution. In their ruling, the court withheld the parliamentary authority to create offences, and to regulate the conduct of individuals in the cyberspace so as to protect the public from harassment, fraud and other online harms where the cyberspace cannot be allowed to operate outside the reach of the criminal law. The court also rejected the petitioner's challenge about Section 28, which criminalizes cybersquatting, ruling that the provision legitimately protects intellectual property rights and prevents deceptive practices in the digital economy. According to the presiding judge, the subject matter of cybersquatting was found to be clearly undermining the trust in digital commerce and infringing on property rights, which therefore does not deserve any constitutional protection. However, sections 22 and 23 of the Act were found to be too broadly framed and could potentially criminalize innocent conduct and scrap thereof. While dismissing other petitions attached to this appeal, the court issued a special guidance to the lower courts and other state agencies, warning about surveillance and interception of powers that must be exercised cautiously. Judges and investigators were also advised to clearly specify the offences under any investigation, the period of interception, and how the data collected should be examined. The bench also warned on how the law could be misused for political purposes if not applied carefully, with reasonable jurisprudence. Thank you and keep on subscribing.